Ms. Butcher is on probation in each of those cases. One for burglary of a habitation, which was a 5-year deferred, and also an unauthorized use of a vehicle. And there were motions to adjudicate filed in each of those cases. And Ms. Butcher was previously here, pled true to counts 1, 4, 5, 6, and 7. I've received the updated report. This was not agreed. Has everyone received that and reviewed the report?
We have, Your Honor.
Yes, Judge.
Are there any additions or corrections?
No, Your Honor.
Not from this.
And what is this, it might say here? The new case is out of Harris County,
She was placed on
probation, right?
probation and sent to the Santa Maria Rehabilitation Facility.
Okay. All right, so Mr. Rojas, you may proceed.
Thank you, Judge. And that's true, Judge. She was sent to Santa Maria through probation at Harris County. And as the PSI points, or the updated PSI points out, she left that facility. I spoke with her about that. She left that facility because there were open warrants out of Jefferson County. She wanted to take care of those warrants, not because she didn't want the help provided there. She tells me she does want to go back to the Santa Maria facility, and there they will help. She's got a 3-year-old son, in addition to being 6 months pregnant right now. And the facility is a facility that will allow her to bring her 3-year-old with her, as well as she will keep the newborn once that newborn is she's giving birth. And she does want the help that Santa Maria can provide, and she's willing to go back there. And that's what she wants the newborn to be once he's born, or she is born. As far as what she wants to do with her life, she told me she was working in the healthcare industry in the past, and she wants to go get her CNA licensing, and she wants to continue doing that when she gets out. She does have a letter she wants to read to you, Judge, and I think if this is the appropriate time, she wants to do that.
Okay, go ahead.
Dear Honor, I have been in jail since April 29, 2025. I left the rehab because I wanted to come back here and turn myself in.
Let me just stop you real quick right there, because the officer called Santa Maria, and the people at Santa Maria, according to what that officer put in this report, said that you left the facility because you changed your mind.
I did not.
Hang on. Quote, Santa Maria is not the best option for me at this time. Are you saying you did not say
I
that?
did not say that. She know why I left because I had a warrant for my arrest and I didn't want the police to pick me up. I couldn't go to the DPS and get my ID and stuff, so I was gonna come back to Port Arthur, turn myself in, and just go from there. But I didn't leave because I didn't want the help. That's why I found out I was pregnant on March 31st. I found out I was pregnant. I was in that rehab. I left because they wanted me to go to get my ID, and I couldn't go there because I had a warrant out for my arrest.
Okay, so you found out you were pregnant in March,
Yes.
and then you went and committed an evading arrest with a vehicle, a duty on striking an unattended vehicle, and an aggravated assault against a public servant a month later after you found out you were pregnant?
I was on drugs, Your Honor.
While you were pregnant?
Yeah, I made the mistake of leaving the rehab and I got on drugs, and the next few days later I got arrested.
But you said you made the mistake of leaving the rehab, but you said you left the rehab to come and turn yourself
Yeah.
in. So
So
you
I
didn't
bought a
leave the
bus ticket.
hang on. So you didn't leave the rehab to come turn yourself in, because if you had, you would have come straight here and turned yourself in, and you wouldn't have these new
I had to
offenses.
catch a bus, so I had to go downtown, wait for the bus to come, and in that time, I caught a charge. I don't want to be separated from my baby, Your Honor. This is my,
So in that time, hold on. So you had left the facility at least by April 17th.
yes,
And then your new charges were April 29th.
yes,
So that's 12 days
Yes.
of waiting on a bus and catching a
I
charge?
didn't have the money, so I got the money together to catch the bus back out here, the Greyhound. And once I got the money, the day I was going downtown, I got arrested. for trying to evade the police because I was on drugs. I was scared and I was on drugs.
So all the times that you failed to report to the probation office, March 7th, March 10th, hold on, there was a third one,
March 12th.
March 12th, April 10th.
I
So,
never knew I had all those dates after the 7th. After the 7th, I thought I was revoked already. After the first time I did report, I thought I had a warrant out for my arrest, and I went to the rehab.
but you talked to the probation officer
I
between
talked to
then,
her on the 7th.
and you talked to her ugly.
I got out of jail in March 6th in Harris County.
Mm-hmm.
I called her that day.
Mm-hmm.
She wanted me to report the next day. I couldn't make it.
Right.
So I guess I talked to her within that week. I don't remember talking to her, but I didn't know that she was giving me more opportunities to report. I would have reported. I thought after the first time that was it.
The reason you probably don't remember all that is because I guess you were using drugs while you were pregnant.
Yes, ma'am.
Yeah,
I didn't know I was pregnant at first, and then I found out.
but then you kept
And I-
using drugs.
Yeah. I need help, and Santa Maria is a good place, and they'll offer me mental health service, and I have an autoimmune disease that they offer treatment for. Jefferson County hasn't been giving me the medication for it. And since I've been here 52 days. They haven't given me any medication, so my baby can, yeah. I don't wanna say it out loud what it is, but, I need the help that Santa Maria offers. I don't wanna be separated from my kids any longer. My 3-year-old is with somebody, a friend, and I want him to be able to come with me. I want to be able to keep my kids with me and get the help I need mentally and with the drugs.
So where do you actually live?
I live on 1825 17th Street,
What city?
Port Arthur.
So Santa Maria is what, 90 days?
It's up to 6 months, 6 months to 18 months.
It was verified through the Harris County Community Supervision Court Liaison that the program is 6 months.
Yeah.
So where did you get the 6 months to 18 months?
They told me at Santa Maria when I was there, it's up to, you can stay up to 18 months.
Mr. Smith?
Judge, I spoke with Misty Hoffman, who was an assistant DA in Harris County, before they sent her to the Santa Maria program. They were thinking about doing that, and she tried to explain to me what it was, and I explained to her. Our intention was not to keep her on probation, it was to seek a revocation in this case. I think everything that she has said up to this point kind of lends credence to the fact that probation is, she's not going to be successful on probation. I think even today you can see that she gets, according to the PSI, becomes impatient, easily irritated, argumentative, and confrontational. She's been non-compliant basically since she started in on probation and has made no progress and has no plan. This is the first that we've heard that she even has a residence in Port Arthur. We had no idea that she had any kind of residence in Jefferson County. She didn't have one prior to this, so I don't
I've
even
been
know
here
whose
the
house
same-
this is.
So here's the thing.
Yes, ma'am.
Talking over people,
Sorry.
being confrontational with your probation officer is not going to get you anywhere. Right?
Yes, ma'am.
So if you have, what's the place in Port Arthur that you have to live?
It's a home. It's a house.
Whose house?
It's my house. I've been renting it
Since when?
since before I got on rehab. I've been using the same address.
Well, but
Before I got on probation.
but you told probation that you didn't come back here, hold on, because you were homeless.
I've never been homeless, ma'am.
You said that in the original pre-sentence
No,
report.
I told her I was at a motel and she assumed I was homeless, but I'm not homeless.
But originally, when I put you on probation,
I gave y'all 1825 17th Street, which is where I live.
if you had a residence here in Jefferson County and you were on probation here in Jefferson County, then why didn't you come back here when you got out like you were supposed to?
I tried to come back, and I did come back. I didn't report because I thought I had a warrant out. I thought I was revoked already.
So you were just gonna wait it out until they came and caught you?
Came to turn myself in, and I got arrested. I was gonna turn myself in.
Everything you're saying is conflicting.
How?
Because you're,
I'm here. I'm here.
yeah, you're here in custody and you're just, I think you've told so many lies to everybody that you don't know how to keep up with them.
It's no lie, ma'am. I was in Houston. I came back, and I came back March 7th. I was here. I didn't report. I was on drugs.
So you were already here March 7th.
I was here March 7th. I was here, and then she told me to come in.
So there's no reason on March 7th that you couldn't have, you were talking to her about needed a bus and all this stuff. That was all just lying back then.
No, I was in Harris County. I got here March 6th. She told me to report March 7th.
So if you were here March 7th.
Yes. Y'all know I was on drugs. Can you please give me the help that I need and let me keep my kids?
I put you on probation in the first place to get the help that you need. I put you on hang on. I put you on probation for 2 felonies with all the resources we have to help you. And instead of taking advantage of those, you came back, you didn't go ask for help, you just had to show up one time and say, I need help, I'm pregnant, I'm using drugs, I need help. It's easy to say you need help when you've picked up 3 more felonies.
I didn't pick them up, they dismissed them. I only got 1. They dismissed the other ones.
Well, I'm sure that was part of some plea agreement. You still got arrested for 3
ma'am.
felonies, serious felonies. Not just little stuff, not a possession case.
Your Honor, please, I do not want to be a felon. I can't complete
Well,
this.
quit committing felonies.
Yes, ma'am, that's because of the drugs in it. I lost a baby last year. I had a stillborn at 7 months pregnant because of drugs. I need help with the drugs and rehabilitation.
Maybe you need to stop getting pregnant for a while.
Yes, ma'am.
Looks like one of the jail incidents also involved an assault of another inmate and an attempted threw a bar of soap and actually hit one of the correctional officers and tried to swing on one of the other correctional officers.
That is okay.
What
I've
that?
never tried to assault a correction officer at this time.
No.
Like jail, prison time, and no.
Let me take So why did you refuse to go to the hospital when you fell?
Because I was feeling okay and I had a doctor's appointment coming up. And I was gonna tell her. The last time I told them I slipped and fell, they didn't do anything in the jail, so I was gonna wait till I go to my doctor's appointment.
But they wanted you to go to the hospital to get checked out.
I didn't know they wanted me to go to the hospital. They just had me sitting in the infirmary.
So you supposedly said you fell, you were refusing to go to the hospital. They told you the doctor wanted you to go to the hospital. You said that you would go, but asked if you could go back to your dorm first. And they said, we're not doing all that back and forth. You asked if you would be transported via van or EMS. They said, don't worry about that. Then you said, I refuse, I'm not going to the hospital.
That's when I talked to Dr. Kim. Dr. Kim told me whatever was wrong, I could tell the doctor when I went to the doctor. So that's what I was waiting on.
So they're making it up that doctor wanted you to go to the hospital.
They wanted me to go, and I told them I was going to wait until...
So, but that makes me, you're not taking care of yourself and your baby.
My baby is fine.
How do you know? If you fell and hit your head and they wanted you to go get checked out at the hospital, then how do you know she's fine or he's fine? You don't know.
No.
Sorry we made you wait so long. I hear that you were a little disappointed in that in the back.
I'm scared. I've never been to prison.
Yeah, well, based on everything that I've already said, based on the fact that you stood here and told different stories about every single thing you said, based on the fact that you've already lost a baby and you're lucky you didn't lose this one, and who knows what's going to happen with this one because you were using drugs, based on the fact that you got felonies while you were on a felony probation, based on the fact that this lady here was trying to help you. You already left the place that you were given an opportunity to go to. Does probation have anything else to add, Ms. Core?
Judge, just that I'm really concerned about the non-compliances she's had at the jail.
Same.
I'm really concerned about that.
So here's what I'm going to do, Ms. Butcher, in cause number 24, DCCR 1732. I feel like you've given me no choice but to make sure that your child and children are safe and that the community's safe. I'm going to find that you entered your pleas of true to counts 1, 4, 5, 6, and 7 freely and voluntarily. Find those counts true. In 24 DCCR 1732, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1733, I'm going to find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to need that signed. These cases will run concurrently, which means together at the same time.
Why would you separate me from my kids?
You separated yourself from your
This
kid.
is my first time being in prison.
Let me tell you,
I've been in jail
listen,
4 months.
I got 10 more years I can add. Hold on, you're not going anywhere. Hold on, you're not done.
That's not right.
I'm handing you the trial court
No
certification.
chance.
You had chances. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. You need to sign that and I'll give you a copy of it. If you had showed me that you could behave in our jail, there might have been some other things that I would consider, but
Thank you.
there you go. You can go back with the bailiff.
Thank you so much for separating me from my kids.
Today is the date scheduled for 2 hearings, I see. We have a motion for summary disposition that was filed by the plaintiff. And then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it's basically has come from me from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be having this whole case situation to begin with. I tried working with that credit union one-on-one myself. It was not necessary for them to go take this route. And now they have put her out here, got equipped because she doesn't have any information. They didn't give her any. And now she wants to use me to work against me, which is crazy. This is why she wants this meeting today. She wants to hear additional information. And I purposely left my information at home. I have additional information other than this makeshift packet that she put together. And I purposely didn't bring it because, as I stated, I want to hear more about her affiliation with this company, and to let her know that the information that she does have is inaccurate.
Okay. Well, now you've asked me to dismiss the case. And in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed a case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's a process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want. Any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So,
Your Honor, can I say something else? I just want to bring out all of the rest of my feelings and information and everything concerning this case on September the 25th for the trial. As I stated before, the reason I don't want to keep giving information pertaining to Ms. Butler here is because she has no information and she's trying to use me to build the case.
ma'am, that's okay. That happens.
You could be talking to them, not me.
Well, let me say this. If this case gets to trial, it is their burden to prove the case, but they can do that by any type of information, whether they got it from you, whether they got it from their client, the credit union, whether they got it from answers that were filed to interrogatories or your response to the complaint. That's okay. That's the way a lawsuit progresses. So it's not like she's doing anything wrong, but if she is using information that she obtained from you.
Well, Your Honor, she's not giving me any. When this
Did you ask for any information?
Yes, but
Okay.
she didn't even answer her phone when I called her.
Well, ma'am,
office.
let me tell you, there is a written discovery. I don't even know if the court had ordered it before, but if I did, there's written discovery that you can use to actually ask for information. Now, from what I'm seeing here, this got filed fairly quickly, this motion. So I'm not even sure that we even did a scheduling order for discovery yet. They filed their motion for summary disposition, I think, before we even got to any of that. And I'm not even sure if you went, maybe you went to mediation. You did go to mediation. Well, at least it was ordered in July. Let's see if you went. I don't know.
Yes, Your Honor, we did go
We
to
had mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14th.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was giving credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting with the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to
Let
address.
me interrupt you a minute. I'm looking on my electronic filing and I see the motion itself, but I don't see, let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and a proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's that. Well, no, here's the exhibits. Okay, let's see if I got a brief with it. Okay, I've got all of the exhibits that you've attached right here. And it just says exhibits, but there's no motion. Let's see, notice of hearing and there's no brief. I've got the motion, which is just your standard motion, but I don't have the argument. Do you know what date that you filed the brief?
On August 18th, the same day we filed the motion and those exhibits.
Okay.
Have
So
the
let me
file
look at
stamped
everything,
copy.
let me look at everything from August 18th. So here's the motion. And the motion does not have anything else attached to it. It's just got a motion. And it appears to be about 2 pages. Then there's a notice of hearing from the 18th also. And that's 1 page with a date to be determined by the court. There's a proof of service from the 18th, which says everything was served on August the 18th. That's also just 1 page. Then on the 18th, here is a proposed order. That's 1 page. Then the next document. Aha! There it is. I must have missed it before. Here's the brief.
No problem, Your Honor.
Okay. All right, go ahead with that, your argument then. You've got your documents attached. I see those.
Yes, Your Honor. This relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers who provide credit union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't filed a response to the motion. Maybe if you want to consider her letter a response to the motion, she still has not presented any genuine issues of material fact that would justify a trial, nor has she stated any valid defenses. This motion is under 2.116, C9 and C10. If she doesn't present anything that would contest this balance, there really isn't much more for the court to review based on what we've already provided. That's why we ask that this court consider denying Ms. Davis Steele's motion to dismiss and granting this motion for summary disposition. Again, there's really nothing to review further at a trial.
All right, thank you so much. Okay, so Ms. Davis Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union. And that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were credited for any payments that you had previously stated that you made, and that there was a prior loan, and then you got this new loan for debt consolidation. And they verified that all of your prior payments were indeed credited to the other loan. And this is a new loan. And that you've admitted that you pretty much owe this loan. There's no question there that you owe that debt. You had missed a couple payments, so that's the default. And otherwise, she says she's checked her balances and this is the correct amount that's due, so that there really is no issue to go to trial on. And if there's no issue to go to trial on, we could enter judgment for the credit union today, because there's no issue. A trial is held when there are actual issues that we're not sure, well, what's the facts? This
Okay,
case, she argues, these are the facts. No one's disputing the facts.
I'm
So-
disputing. Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit
Ma'am, there's
union.
no evidence of that.
That they have. The paperwork that I,
excuse-
let me finish
excuse me.
talking. Your
I
Honor.
need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm to represent the credit union, because the credit union is trying to collect a debt. And they typically do hire debt collection firms to do that. So
Okay,
you
Your
have
Honor,
to-
let me
ma'am,
finish. Let me finish.
Ma'am, you can't say that to the judge.
listen,
okay,
I'm sorry. I'm sorry.
Okay,
I'm not there,
okay.
and I'm not going to try to overtalk you.
Okay, I'm sorry, Your Honor.
And I'm the one that knows what's going on. I understand the law and I understand this process. And I've looked at these documents and I'm trying to explain it to you. But if you want to overtalk me, that's not going to work. Now, I'm fully happy to listen to anything you have to say. That I am willing to do. But if it's not right, I'm going to have to tell you that. And we got to move forward from
I
there.
understand.
Okay, go ahead.
Okay, so here's the whole situation. I took out the loan and I did that. It was a double loan. I started with one. They merged that first one in with the second one. It became a combined one loan. Out of that one loan, I have paid over $8,000 and plus for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I have
me.
it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
It's not accurate. They have false information regarding what I have paid. And everything else that she's saying about this, what they have done is false and against what is actually true.
Okay,
And
ma'am.
I wanted to bring out all of my information
We don't have
during
it.
the trial.
We
That's
don't.
what I thought I could do.
We don't get there. This is the date to do that. This is a motion for summary disposition. That means this is the date where the case could be totally dismissed and we don't get to trial based upon their motion. This was the date for you to file a response, like she said, which you did not do, but that's okay. If you had brought some information today, we could have dealt with it orally to some degree. But if you don't have anything, I can't just go on your word that they did something false.
I have it
I
at
gotta
home.
have document. Ma'am, you were supposed to, I don't know why you would come to a court hearing without the
Because
proper.
I thought this was just a hearing, that we were just supposed to, voice. It was I thought it was similar to that orientation we had, which by the way, she started with one sheet of information. Then all of a sudden, after I submit my receipts, she comes with a bogus packet of which over 99% of this packet is incorrect. And this is why I thought this was just another hearing to voice why it should go, like you said, go any further or not, because none of what she has in this packet is correct. And they
I have
have
no
not.
evidence to show that none of what she has in
And
the
I'm
packet.
sorry, I made the mistake and left it it's at home. I have the information to show it. And they have it. They have the accurate records of how much I have paid, but not giving me credit for it. I do not owe the amount that they're saying, and I should not be assessed anything any different. This is a collection agency that has gotten that account. They want to take it over and want me to start from a whole big balance amount of which is not true. I have paid this credit union over $8,000, $8,231.07. And they are not giving me the credit for it. And then they want to continue on with a huge balance. How can you come with a balance of 11,000 plus when both of the borrowed amounts were 7,000 each, and I have paid over $8,000 plus?
Ma'am,
There's
I don't
only
know. You have to look at-
3,500 left.
You have to look at the terms of your loan agreement. I'm sure there's interest and penalties on late payments that apply.
And on that, I'm glad you mentioned that, Judge. And what she said earlier about missing some payments, I've never missed. I've been late, and I admit that. But the late ones I have gone up with and moved forward. There's no way I could reach $8,000 plus not paid. I have paid late. I've never missed. So that's an incorrect statement that she has made. This credit union is crooked and biased and is sorry for that she's representing them on those premises, but that information that she has given is incorrect. And like I said, I didn't understand. I thought I could bring my information to the court. I thought we would be having a case on the 25th of September. And so my information is valid, but it is at home because I thought she was trying to continue to get more information from me to base her case.
Now, if you had read the motion, it says in the body of the motion that she's asking the court to enter a judgment against you today at this hearing. That's what the motion says. It doesn't say she's trying to get any information from you. It says she's looking for a judgment. And if she gets a judgment, that's the end of the case. There is no trial.
Well, Your Honor, I would still like to request the trial to go through for the 25th.
I can't do that, ma'am.
Allow
I
me
have
to
to
do-
resolve the motion today. I can't do that. That's why she filed the motion.
It's inaccurate, and it was not my clarity. I had a lawyer, through the Lakeshore situation, and they completely just dropped me midstream, no assistance. And when I came back in, they later came out here. They came to the court and were meeting people downstairs. I asked, why was I dropped? They could not give me a valid, only thing the lady said was, well, we're short-staffed, but yet they had started in the middle of my situation. It's unfair to me to have taken on this type of a situation by myself. I had my legal help that I thought I had snatched completely from under me for no real valid reason. They had already started. So to tell me that they were short or they have a lot of people, that was an injustice to me because they had already started assisting me. And had I known that this meeting today was going to involve my not going on to the 25th of September, I would not have made that mistake. And that's where legal defense comes in. And I've been done a grave injustice where ever since this mess here has started regarding the lies regarding what I have paid to this credit union.
Okay, let's hear back from the plaintiff before I resolve this.
Your Honor, the only point I'll bring up is Ms. Davis-Seal said she never missed a payment, she was only late. Being late on a payment does still constitute a default under the loan agreement. She was late on a few payments and made them, but she also, from the transaction history attached to the motion, missed a payment in August of 2023, October of 2023, and a short payment in March of 2024. That's all in the transaction history attached to the motion. Thank you, Your Honor.
Your Honor, may I say something?
No, ma'am. At this point, I gave her an opportunity to respond back to you because she has the burden of proof. Because we can't go back and forth like this all day. So I've given you a chance to speak, and we're now looking at her motion, and she's argued her motion in conjunction with her response to your motion to dismiss. As far as your motion to dismiss is concerned, I'm going to look at the body of it again, but it really doesn't have a legal basis in it for the court to grant you a dismissal of the case. What you indicated in the motion and on this record today is that you're being sued, of course, by a Vibe credit union, that this lawyer is representing them. That's all true. That you had tried to work things out. That's probably true. None of that's a basis to dismiss. And that you are no longer, you found out that about this case, and now they're using the debt collection firm to represent them, that you're not interested in going further with trying to resolve it, I guess. You say that Miss Baker's agency is a farce, trying to collect money because they now own the account. There's no evidence of them owning the account, and they have not filed this lawsuit in their name as a debt collector for them to try to collect the money. They filed this in the name of the Vibe Credit Union to try to collect the money for that client. So there's no evidence that they bought the debt. There's been no transaction history showing an account purchase from Vibe or anything else. You indicate that you were informed by a source of how debt collection works. And that is probably accurate. They're just not collecting the debt for themselves. It's probably true. They do buy debt. It happens. We have cases like that every day. And there's usually a purchase of an account, an assignment of interest, and we can track the chain of title down to the plaintiff. That's not what's happening here. The plaintiff's law firm.
Can I make another statement on what you were saying just now? about the
Ma'am, I'm
information.
trying to rule, and when I'm ruling, that's it. Nobody else
Yeah, I
gets.
didn't know you were ruling. I thought you were just reading
No, I'm
something.
going through your points to make a clear record of why I'm about to deny your motion to dismiss this case. So yes, they may buy debts, but that's not what we have here. You say you don't owe the debt collection agency any money. That's probably true. And they're not looking for money from you. Vibe Credit Union is looking for money from you.
I'll just call him.
You indicate in here that there's some false allegations. I don't know what those are. You're still talking about purchasing of business records. There's just no evidence of any of all that. You've got that into your head, but there's no evidence of any of that. And basically, we get down to it. You think they've disregarded your receipts. It's the similar things you're arguing on her motion, but that's not a basis for me to dismiss the case. So anyway, you say you feel it's unjust, but you had a loan with the credit union. And so they have a right to try to file a lawsuit if the loan agreement was breached or defaulted in some kind of way, then that's what they've done here. So that's no basis to dismiss the case. And I don't see anything unjust about that filing of a case if they have a loan agreement with you that was allegedly breached. So anyway, you asked me to sincerely consider this request, which I did, and I do not see a basis to dismiss the case. So your motion to dismiss is denied. As far as the motion for summary disposition is concerned, it's brought under Michigan Court Rule 2.116C10, the basis of which is that there is no genuine issue of fact that requires a trial. This motion was served upon and filed with the court and served upon the party defendant at least, let's see, at least 28 days ago, specifically. It looks like it was on the 18th of August. So at this juncture, the defense has had notice of the motion, notice of today's date. She's appeared here today. She could have filed a written response to the motion. She did not do that, but she appeared and made her argument that there's some kind of fraud she thinks that the credit union is perpetrating against her. She's made her argument that she was not fairly credited with a number of payments that were made on her loan, and she brought no proof of anything today. And this is the date of the hearing where the proofs should have been brought, because in a motion for summary disposition, the plaintiff has the burden to bring forth some evidence. And once they do, then the burden shifts back to the defense to bring forth additional evidence to refute or rebut the plaintiff's evidence, and therefore creating a question of fact for trial. We don't have that here today. There's nothing here that shows.
Here it is, Your Honor, here it is.
Ma'am. Here's what?
I just found it. It's in this packet. I thought I just had her information, but my information about what I paid is here on this sheet.
Okay. And quite frankly, let me take a look, because I don't have that. And everybody is required to provide in advance. That's why we give all this time for these motions to be heard, so that everybody can review it and see it, including the court. I've got all the documents I need in my file right here, except for what you got there. And you're asking me to look at something that I can't even look at this point. So I'm going to ask counsel, could you please grab what it is that she's got and tell me if you've looked at it before?
Your Honor, I have not seen this before. It looks like a handwritten ledger. Again, like I mentioned, Ms. Davis Seals had provided to my office all of her receipts. And
I
my
know
client,
and does that look like a listing of the receipts similar to what you went through?
yes, Your Honor, it does look similar. She had provided the ledger and copies of her receipts before. My client double checked, made sure she got credit for what she had made. This does not look different to me.
So specifically, ma'am, you would have to then show me, because I'm gonna look back at her exhibits. Which one of the exhibits has your full check of all the receipts?
Your Honor, it's exhibits 2 and 3 that have a full transaction history. And then exhibit 4 also has all the statements that would have been mailed to her. So if there ever was anything missing, she would have had the opportunity to tell us. But again, she already provided all her receipts to me. I did not include them as an exhibit to the motion because my client executed an affidavit having reviewed the business records and indicating the balance.
Okay, so let's look at exhibit 2 and 3. And just so it's clear, I've got 43 pages of exhibits from the plaintiff here.
Sorry about that, Your Honor, but we felt it was necessary given what her concerns were.
Yeah, and you just have to wait a second because the online system must be very busy today when other courts are using it, and so therefore it's frozen.
Your Honor, can I make a statement? I have another statement I'd like to make regarding the rest of my evidence that I told you I left at home.
What is it?
The other evidence is that they keep arguing the point that I only had one loan, but I had two. And that's what I was going to be bringing out.
She said you had 2 loans.
She said two.
She did. She said you had a previous
The
loan.
2 combined then are the ones that show that it was a one amount and that all of the monies that I paid towards that one account was not accounted for because there were 4 in the first contract
Well,
before they blended it in with the second one.
I don't know. She said it was a
But she didn't say it was
a first loan, and then she said it was a debt consolidation was the second loan. I believe that's what she said.
it was
So, and
blended.
she said all the payments that she saw that you made were properly credited to that first loan that you made.
Or they were not. They were not.
Well,
Otherwise,
tell me which one was not credited.
none of it. Really much.
None of it.
All they have me credited for, according to their balance, is 2,000 and something, and I paid $8,231.07. So in their paperwork, when they give the final tally and total of what the remaining balance is, they're still saying that it's 11,000 plus. If the 2 combined came to 1344, something of that nature. And when you take 8,000 and something from that total amount, you're gonna end up with 3,500 or so. How can they still be coming up with 11,000 plus when I have paid 8,200 plus?
Okay, I'll let her answer that again. Go ahead.
Your Honor, maybe this will help. If you look at Exhibit 1, which is actually the loan agreement,
Mm-hmm.
on the second page of it, at the very top, I'll let you get there, so it's probably easier once you're there.
Okay, what's the very top say?
Itemization of the amount financed. You'll see that she financed $13,644.13. That's page 2 of the loan agreement. It says amount given to you directly, $7,000.
Wait
Amount
a minute,
paid
I'm missing something. I'm looking at something different then. Let's see. I'm looking at Exhibit Index Loan Agreement, Exhibit 1. Then here it says Exhibit 1 Loan Agreement. Then the next page says Loan and Security Agreement Disclosure Statement.
Go to the next page after that. Your Honor.
Okay, that's the second page then.
No
Okay,
problem.
there it is. Itemization of amount finance. Go ahead.
$13,644.13 was financed. Amount given to you directly, $7,000. Amount paid on your account, $6,644.13. So she thinks she paid $8,000. I think she's considering the $2,000 or so she's made since this loan atop the prior loan's payments. I think that may be where confusion lies, but my client did lay this out right on the loan agreement.
And it shows 6,000, which was what she paid on the other loan. Is that what you're saying?
It's representing that other loan was paid off to the amount of $6,644.13.
Right. And she
And-
got $7,000.
Yes, Your Honor, and the interest rate on this was 14.99%, so that accounts for this balance going up. There are also fees for late payments. The interest dropped to 13% as of the date of filing of the lawsuit as required by statute.
Okay. Ma'am, I don't understand. It shows right here on the document.
Those papers are inaccurate, Your Honor. They're inaccurate. I said that when I first started out, I said she had no accuracy in her paperwork. And I said, and I'm sorry that I had left mine.
Okay,
at
let
home.
me say something to you. This is a document that you would have signed.
I have the signed ones. at
No,
home.
you what?
I have the signed ones.
No,
at
you
home.
didn't. You didn't have to take the loan.
No, I'm saying that I do
Fine.
have signed accuracy. What they have come up with is since this dispute, they
No.
don't have, she doesn't even have the first copy of the law of the
Ma'am, it seems to
loan.
be,
She has none of it.
it
none
seems
of
to be your payments seem to be in the disclosure statement.
That's what they're saying.
Well,
But
you
like I
signed,
said,
ma'am, I'm looking at your signature on it.
I have accuracy.
How you gonna say
of
this is
both
inaccurate
sides.
and you
Because
signed
they
it?
have doctored it. They have doctored it to say what they wanted to say. I have the
Ma'am,
two
listen, I'm gonna
access
have to go
contracts.
ahead and finish ruling on this. I'm gonna end up having to grant this motion for summary disposition. There's just no basis for what you're saying. I'm looking at the original loan document for this, which seems to take into consideration the payments that you made previously. And then you've already made some payments on this loan agreement as well, which equals the amount that you're saying you paid. And it's all showing here.
No, it's inaccurate. Those
All
are.
right, well, I don't know, but I don't see any genuine issue
Accurate.
material fact other than you complaining that it's inaccurate. I don't
No,
see
it's
anything.
not. I
You haven't
wouldn't
showed me
extend it
one
up.
thing that's inaccurate, so therefore the motion is going to be granted. If you think there's something wrong, I'm so sorry, but you do have a right to appeal, and you might want to go downstairs and appeal to a higher court within 21 days of today's ruling or whenever this order gets entered. But there's just no issue here that I can see that would require an actual trial here. So I'm going to ask the plaintiff to please prepare the order on both the motion to dismiss being denied and for the reasons stated on the record, plaintiff's motion for summary disposition is also
Yes.
granted.
Yes, Your Honor, thank you.
Okay, and that's going to complete this matter.
Thank you, Your Honor.
All right, and what's your name, ma'am? All right, so let me take a look at your file, Ms. McKinnon. Okay, so you filed an objection to a Henry Ford Health. That would be a work garnishment.
Yes, ma'am.
And let's see. That was from May 19th of 2025. You claim that the judgment has been paid off?
Well, to my understanding, because it was quite a few years ago, I owned a business and the home was not up to par. Everything in the house was falling apart. So when he took me to court, I was withholding rent, not due to not being able to pay, but due to, the house falling apart and me having to, run my business under, unreasonable, conditions. So when I came to, you had filed that I had put the money into escrow. And I was under the impression that I was putting the money in escrow. When I went to go look for the receipts, I couldn't find them because I had just moved, which is also why I didn't receive the first motion for the garnishment because it was sent to the wrong address. And so luckily I found the garnishment. Luckily, the garnishment was put on my paycheck and I noticed it within the first paycheck and I was able to object to the garnishment within the maybe 14 or 21 days.
Okay.
At the time of the objection, I filed a motion to either reduce it or to just dismiss it completely, because I was under the impression that the money that I put in garnishment would go toward my balance. So when I was
any money that they did receive in garnishment would go to your balance, but right now, you have to show me where the judgment was paid.
well, I did ask at the front desk for what was put into garnishment. She said $5,000, and with that amount of time, we were going.
Ma'am, you should be able to tell based upon your paycheck stubs or get paycheck stubs from your company the actual amount that they paid.
Oh, I'm sorry. I thought you were referring to the amount that I supposedly owed them. The garnishment was.
No. Listen, we have to go by what the judgment is. And so I could probably look up and see if you got a judgment, if it's on here.
The garnishment was $350 per paycheck. I can't afford that with two children.
Okay. First of all, we're only here as to whether or not you paid the judgment. If you can't afford it, that's a whole different issue. And you'd have to file a motion for installment payments if you wanted to do that. But that's not what you have here today. You've only got a motion, an objection saying you paid off the whole debt. And I need to find out how much the judgment was, and I don't have a file. So I'm going to ask the clerk, can you pull this up on JIS and tell me the original amount of this judgment, please?
It was roughly $24,000 because it was $5,000 a month in rent.
Madam Clerk, can you hear me?
Yes, Judge, one moment. You said the amount of the original judgment?
Yes, it's an LT judgment. Was it a possession or money judgment? Because I don't have anything on base other than the garnishment.
Looks like a judgment by default was entered May 10th of 22 for $19,869.48.
Was it a money judgment or possession judgment or both?
No, Judge, it doesn't say, it just says judgment by default entered.
Well, I'm assuming it was a money judgment because they accepted a garnishment on it.
Yeah.
It doesn't say so though.
And then, Judge, August 16th of 22, a judgment by default was entered for $24,950.
Why is there two judgments in one case? I would need to see the file. I have nothing that I can look at on base. But the bottom line is, whichever judgment is correct, you have to show me that it's been paid off.
Well, the reason I filed the motion is because I didn't believe that I owed anything because I thought the money was put into escrow. So I didn't understand. I mean,
I don't know what you mean by, first of all, you can't attack the judgment on an objection to garnishment. You can't do that. The judgment is good. The judgment stands. The time to attack the judgment was when the judgment was entered, but you didn't come to court. So it was a default judgment. So it is what it is. And the way the law is on garnishments, you cannot attack the judgment amount. There's only certain bases to attack the judgment. And one of them is that the judgment has been paid, but you would have to show that it's been paid. And I don't know what you mean by you thought it was in escrow.
I was paying $5,000 a month, and to my understanding, I mean, it was a few years ago, but to my understanding, the
You were
money that I
paying
was
$5,000 a month?
yes. And that money was being put into escrow. And so I was very confused when I received.
Well, where was the escrow?
Oh, I'm sorry.
Where was the escrow?
Where was I paying the escrow to?
Yeah.
The court.
Okay.
And so when I went to
but
file
it's not our job to go find out what you paid. It's
no,
your
I understand that.
Yeah, it's your job to show me. You would have to go, you need to go and refile this motion if you really
Yes.
serious, because you don't have anything to show me you paid it. You would have to go and get information. You go downstairs to the clerk's office. You can get a copy of the check that they released to the plaintiff for escrow at the time of the judgment. If that happened, you can go to your employer and see how much money that they took from your paycheck each month towards the judgment. And then you would have to say, come back and refile this and say the judgment's been paid. Because right now you have no evidence. You're just saying what you thought. I can't go by what you thought. Okay. So I'm going to have to deny your objections today and release any money that is being held would have to go to the plaintiff, because there's
what plaintiff though? They didn't even come to court. What plaintiff?
Ma'am.
Am I supposed to be the only one that comes to court?
Ma'am.
Because
Ma'am, I can't violate the law. Okay, I just can't. And even though he's not here to make any argument. I still got to look at the validity of what you're saying. I can't just violate the law and say, okay, well, forget it. He's not here. You win this. I can't, because
isn't that what default is? If I don't come to court, it's a default in their
ma'am. Okay, I'm sorry if you don't like the ruling,
because I don't understand. That's all
I'm telling you. You're asking me to make a decision that the judgment is paid. That's what your motion says.
Not what I thought I was making. Okay. When I filed a motion stating, to my understanding, because I'm not a lawyer and I'm not a judge. So all I know,
you're not listening to the judge either. So I'm
not understanding what you're saying. So all I'm asking for is clarification.
I tried to tell you.
Like I'm not, but I didn't understand. So I'm asking for more clarification because
what is it that you would like to know?
Okay, I would like to know that when I went down there and I filed a motion, I expected to come to court with a plaintiff. If I was to come to court and not come to court, it would be a default judgment to the plaintiff.
This is not a judgment. This is a post-judgment hearing.
Oh. Appearing in person for a hearing. This doesn't say appearing in person for a post-judgment hearing. I don't know the difference.
Okay, that means it's
she also can't even bring up on record which amount that I owe. So it seems to be a lot of miscommunication and lack of clarification on both ends.
Okay.
Because she's unable to bring it up as well.
Ma'am. I don't know what you mean miscommunication. This is a garnishment objection. It's very
she's unable to bring up how much I even owe on court record.
Okay.
So how am I supposed to know how much I owe if even the court can't bring up how much I owe?
Go downstairs to the clerk's office and they will be able to pull it up for you at the clerk's office.
Shouldn't the plaintiff be here to show how much I supposedly owe them? Isn't that what a hearing is for?
Okay. First of all, it's your motion, not theirs.
No matter who files the motion, aren't both parties supposed to appear?
No, they don't. Not necessarily. It doesn't always happen that way.
So if I hadn't shown up, it would have happened which way?
If you hadn't showed up, it's going to happen that I don't have any evidence that the debt is paid. So I would have to deny the objection.
There's also not any evidence
you did show up, and I still don't have any evidence that the debt was paid.
There's no evidence that anybody can show of what I even owe.
Ma'am, that's not the question here. The question is, did you pay the judgment? You got to go downstairs and get a copy of the judgment. I don't have it online here, so I can't see it.
So I should refile, and what should I refile so that I can do that when I
You
go
could
downstairs?
refile the same motion if you feel you paid the judgment.
Okay.
You
And
could
if I,
object to it.
and if it says, if I go downstairs and I get the proof that of whatever was paid, when I go down to the court clerk and she shows me what was paid and what was released to Daniel Winter, I can refile. If it says supposedly that I did whatever was released to him on that day, if supposedly, okay.
If it was 19,000 or whatever the amount is,
It
then
should be clear. It should be clear. But if I didn't, if I did,
ma'am, I tell you what, why don't you go downstairs and look now and come back? Okay?
I'm
Just
just
go
trying
down there right now.
I don't want to waste any more of the court's time, so I want to clarify it now. so I
No,
can-
well, no, go down there right now. I'll wait for you, and I'll do something else.
But I would rather to ask you though.
Now
if-
we gonna do this today. So just go down there, ask them for a copy of the judgment because I don't have it, and I don't have a file. And as a matter of fact, I'll ask the clerk to get a copy, whatever the file is. We can ask the clerk to pull the file and ask them to get you a copy of that judgment, and we can look, and you can ask the clerks downstairs to show, because they should have a copy of whatever was released out of escrow here.
Okay, and do I ask them my options after that? Can I lower the payments if it hasn't been paid or whatever?
That's a you don't.
Ask them that?
You got to file a motion.
I'm asking, do I?
Yeah, I'm telling you, you could file could file a motion for installment payments on whatever judgment is still outstanding. But that's a different motion that you're not here on today. You understand what I'm saying?
I understand now. Yes, I do.
Okay, so go down there. I will ask my clerk to try to pull the file, but I'm gonna let you look at it first and then have her bring it upstairs. Then you can look at it, you can see how, and they can show you down there at the counter what was released back in escrow to the plaintiff. I don't know. And then they can show you what the amount of the judgment was.
Okay, yes, ma'am.
All I have is from the most
We don't
recent
have
thing.
anything.
Yeah, I have some things, but we switched over to online, and not everything was moved over. Some things have a physical file and things online, and this is something that has both.
Yes, ma'am. I'm going downstairs to do that now. Thank you.
When you come back, we'll deal with it. Okay.
Yes, ma'am. Thank you.
Okay.